This meeting is called pursuant to the provisions of the Open Public Meetings Law. The meeting notice was sent to the Burlington County Times on November 6th of 2023, the Courier Post on November 7th of 2023, and advertised in said newspapers on November 12th of 2023, and posted on the website and the bulletin board in the municipal building on November 6th of 2023, and has remained continuously posted as required by the statute. In addition, a copy of this notice is and has been available to the public and is on file in the office of the municipal clerk. Can we all stand for the flag salute?
I pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all.
Okay, can we get a roll call?
Mayor Klaus?
Here.
Mr. Montgomery?
Here.
Mr. Levinson?
Here.
Mrs. Gilmore?
Here.
Mrs. Evans?
She's here. She's on YouTube Live.
Okay.
Okay, let's get an approval for the regular committee minutes of November 9th, 2023. Can I get a motion?
So moved.
Second?
Mr. Levinson?
Yes.
Mr. Montgomery?
Yes.
Mrs. Gilmore?
I wasn't here, yes.
Mrs. Evans?
Can Anna?
I'll let you know. She's texting me. Oh, yes.
Mayor Klaus?
Yes. Okay, can we get approval for the executive session minutes of November 9th, 2023?
So moved?
Second.
Mr. Montgomery?
Yes.
Mr. Levinson?
Yes.
Mrs. Gilmore?
I wasn't here.
Mrs. Evans?
I'll let you know.
Mayor Klaus?
Yes. Okay, we have a presentation with our attorney on voluntary ethics training for elected and appointed municipal officials.
Yes.
I handed you all some, so I think there's
So, John, I didn't get one. Perhaps you
Thanks,
don't think I
Chris.
need the training? Oh, I did. Thank you.
Sure. It was nice of you to make copies for everyone, John.
Hey, you know what the heck?
Hey, I tell you.
It's the holidays.
There you go.
I think that was that special relationship we built when we were in Atlantic City. That's what caused it.
Well, first of all, thanks for allowing me the opportunity to spend some time this evening with you to talk about this. And, you know, it's really something I think it's just sometimes taken for granted. I've been doing this 40 years, and I will tell you that the hundreds of elected officials I've represented, you know, it's a handful that you really had to worry about. I mean, people do this for the right reasons. You know, you do this because you're giving back to your community, and nobody wants to get tangled up in ethics issues. And if you do, you're in the wrong business, right? So just a couple of basic things. One, you know, the law in everywhere, but in New Jersey particularly, presumes, not just assumes, presumes that municipal actions, whether it's an ordinance, whether it's a resolution of the Joint Land Use Board, carries with it a presumption of validity and legitimacy, right? Legitimacy is a pretty important word in there, that the proceedings were conducted appropriately, that the people who voted approached the matter fairly, right, and with proper motives. In fact, there is also a companion presumption that officials act in good faith and with a reasonable belief in the appropriateness of their actions, right? But that, unfortunately, isn't always the case, and as a result of that, we have this, unfortunately, cynical view by the public of officials, right? And it's troubling because, as I say, most local officials do this for the right reason, right? But there are landmines out there that you don't always recognize right away, and so it's important to understand this. And I really would, you know, not necessarily this evening, but spend some time reading the commandments in here, in the local government ethics law, because they're really important for how you conduct your business. There are so many allegations of conflict of interest. Oh, that's a conflict of interest. Oh, that's an ethics violation. You know, we used to have a rule that if you have to ask, don't do it, right? But that's really too simplistic because it's not always the case. And there are so many nuances associated with ethics issues that the better course is to ask the attorney, ask whoever is responsible for giving you that advice as to whether it is a conflict, whether it's a disqualifying conflict, whether you shouldn't vote, or whether you should step down. You know, not everything requires you to step off the dais. There are degrees, as with everything else, right? And there are two areas of ethics that we look at, right? One is what we call the common law, and I'll go through them in a minute. And then in 1991, the legislature codified the common law into what we call the local government ethics law, right? NJSA 40 capital A colon 9-22 point whatever at sec. And that's what most people look at. But you really have to understand both the common law in order to understand the local government ethics law. So let me just, you know, there are four situations. Well, before I do that, the common law is, as I say on page 1, a public official is disqualified from participating in judicial or quasi-judicial proceedings in which the official has a conflicting interest that may interfere with the impartial performance of his duties as a member of the public body. And, you know, when you take the oath, right, impartially and justly are the words in there as to how you shall perform your duties, impartially and justly, right? And that impartial part really goes to the conflict issue, right? That you can't serve two masters. I can't be voting on something that I or someone in my family or a really close friend has an interest in, right? So we'll walk through that a little bit. In the common law, the first category of disqualification of the four categories was a direct pecuniary financial interest, right? So you can't vote to award a contract to a company in which you have a financial interest or someone in your family has a financial interest. An indirect pecuniary interest would be, and I use the Princeton University example because it's an old one and it's a good case, but in Princeton, in this Griggs case, there was somebody employed by Princeton University who was on the Princeton Planning Board. They were not allowed to vote on an application that Princeton brought before that planning board because they're employed by Princeton, right? Or another example is you can't vote to award a contract under, take number 1 and slide into number 2. You can't vote to award a contract to a company with whom you or your business or your employer does regular business, right? That would be an indirect benefit that you would be bestowing on them. A direct personal interest, so we go from pecuniary, financial, to personal interest, right? A council member who votes to either award a contract to a company owned by a woman who was her maid of honor in her wedding, or if they had a really bad falling out, who votes to deny her company a contract, right? I mean, it's a personal involvement, personal conflict. And then the indirect one is a member of the planning board should recuse himself from voting on an application if a family member or an organization or a company in which she holds a leadership position owns property within 200 feet of the subject application. And so that leadership position issue is important because you might work for a company and you're one of 500 employees, right? And there's something coming before the committee. Smart move is to recuse, but I don't know that it's necessarily a conflict. And in that situation, there's a pretty good quote. It's not in your package, but there was a situation in Montclair a few years ago. It was a church case, and the court had to determine whether an ordinance that was adopted by the township, which would facilitate the construction of an assisted living facility on a site next to this particular church, created a conflict of interest for the mayor and a member of the council who were members of that church, right? And the court concluded that the extent of their involvement needed to be evaluated by the trial court and sent it back down for an understanding, well, how involved are they in their church, right? There are a couple of cases that came out where, look, if you attend services once a month, that doesn't disqualify you from voting on something. I mean, just, you're not that involved. So the court said this: The longstanding conflict of interest rule reiterated in this decision should not deter public officials from becoming involved in private organizations. It applies only when public officials serve in a substantive leadership role in an organization that brings or opposes zoning applications, or that is the owner of property within 200 feet of the property in dispute. The rule should not discourage public officials from working for a religious institution, for community groups, or other organizations, many of which cannot provide critical services to their communities without the time and talents of their volunteers. In the rare circumstance in which public responsibilities and volunteer commitments conflict in a land use dispute, there is a simple solution. The public official should refrain from involvement in the matter. With careful attention to the potential for conflicts between public responsibilities and private affiliations, officials may assist organizations and preserve public confidence in the integrity of local government. Again, they're all fact-specific situations, right? You just don't know, and you don't know if the extent of the involvement in the private association is enough to disqualify you from your public responsibility. And that's why I say, always disclose these potential conflicts, get the advice from your attorney, and then you'll know. And if it requires recusal, then you recuse yourself, right? It really is better to be safe than sorry. And on page 2 of this handout, there are a couple of these things, and I call them nuggets of wisdom. These cases go back 60, 70 years. And the first one, the question is whether the officer, by reason of a personal interest in the matter, is placed in a situation of temptation to serve his own purposes to the prejudice of those for whom the law authorizes him to act as a public official. And in the determination of the issue, too much refinement should not be engaged in by the courts in an effort to uphold the municipal action on the ground that his interest is so little or so direct, right? So again, back in 1956, the idea was you have to, and it really still is, err on the side of caution, right? But then you have in that third bullet point, it is the mere existence of the interest, not its actual effect, which requires the official action to be invalidated. It doesn't matter if at the end of the day that vote wouldn't have changed the outcome. That vote is disqualifying, and if a person voted and they had a conflict, the whole vote is disqualified. You have to redo the whole thing. If you find that somebody, it was a 4-1 vote in favor of doing something, it might have been a 5-0 vote in favor of doing something. If one of the persons involved had a conflict of interest, sure. If one of the persons who voted had a conflict of interest, and someone challenges the action on that basis, the court doesn't say, well, it still would have passed without the offending person's vote. So we'll just strike that vote, and now it was a 3-1 vote or a 4-0-1 vote. The whole thing is voided, right? Because that vote taints the entire process, and now you have to start whatever it was all over again, right? And then the last bullet point on page 2, whether a particular interest is sufficient to disqualify a public official is a factual determination that depends on the circumstances of the particular case. The question will always be whether the circumstances could reasonably be interpreted to show that they had the likely capacity to tempt the official to depart from his sworn duty. And we'll talk about that reasonableness under the local government ethics law. But when I say there's nuances and not every apparent conflict requires recusal or disqualification, the last bullet point in the middle of page 3 is kind of what we talk about. Local governments would be seriously handicapped if every possible interest, no matter how remote and speculative, would serve as a disqualification of an official. If this were so, it would discourage capable men and women from holding public office. Courts must also be mindful that to abrogate a municipal action at the suggestion that some remote and nebulous interest is present would be to unjustifiably deprive a municipality in many important instances of the services of its duly elected or appointed officials. Again, it goes back to the nuances. Not everything that looks like it might be a conflict is a conflict, which is why I go back to the original, you don't say anymore, well, if you have to ask, don't do it. The answer now is if you have to ask, get an answer. right? Get an answer. And you have to disclose all the facts, otherwise the answer is really a half-ass answer, right? It's not a fully informed answer because the question wasn't fully developed, right? So then we move from the common law in these old cases to the local government ethics law. And, I give you the whole citation for the findings and declarations. And these are really important, right? These are the underpinnings for why the legislature decided it was time to take years and years and years of case law, bless you, and make them the statute, to codify them. Because one, public office and employment are a public trust. The public is trusting you with the business of local government, right? Local government is a business. People always talk about at open public meetings, right? They'll come to the microphone and say, this is our meeting. It's not your meeting. It's the governing body's meeting. You're invited to it, right? You trust them to do what they're going to do in the sunshine, which is why it's called a sunshine law, except for the exceptions allow us to go in the back room and have closed session. But it is a public trust. Employment, not just elected, employment is a public trust, and appointed officials are subject to and expected to meet that public trust. The vitality and stability of representative democracy depend upon the public's confidence in the integrity of its elected and appointed representatives. It's really true, and what I like after doing this for 40 years representing governing bodies is the reiteration that it is a representative democracy, right? People come up and say, you didn't ask me, you didn't ask us. Well, this is not a democracy where we put every question that the governing body gets on a ballot, right? It's a representative democracy, and they're the representatives, right? So I particularly like the fact that they reiterated those two words, representative democracy. And C, whenever the public perceives a conflict between the private interests and the public duties of a government officer or employee, that confidence is imperiled. We'll come to that again under this appearance of impropriety. And we'll talk about, what is a legitimate perception of a conflict, not just a knee-jerk reaction to accuse somebody of a conflict for whatever reasons. It may be September, it may be October, it may be getting close to that first Tuesday in November, which is when you hear a lot of nonsense about conflicts of interest, right? But that's why you got to be careful about not everyone is not a conflict of interest. And then D, governments have the duty both to provide their citizens with standards by which they may determine whether public duties are being faithfully performed and to apprise their officers and employees of the behavior which is expected of them while conducting their public duties. And that's why these next things under 22.5 on page 4 are important to understand. Under 22.5A, no local government officer or employee or a member of his immediate family, which is spouse or dependent child living in the same household, a member of his immediate family shall have an interest. And an interest in the local government's law, ethics law, is defined as ownership or control of greater than 10% of the profits, assets, or stocks of a company, excluding nonprofit organizations and labor unions. Shall have an interest in a business organization or engage in any business, transaction, or professional duty which is in substantial conflict with the proper discharge of his duties in the public interest. A substantial conflict is not defined in the statute. So again, you come back to what's it look like? What's the actual effect of it? Is it really a conflict? And so there are areas, even in the local government ethics law, that are open to interpretation. And again, that's why all of the facts have to be out there so that an informed piece of advice can be given as to whether indeed it's a disqualifying conflict and you should recuse yourself. C is pretty obvious. No local government officer or employee shall use or attempt to use his official position to secure unwarranted privileges or advantages for himself or for others. Don't try and get one of your closest friends a job in the Department of Public Works or in the Recreation Department. Don't get involved in that. Don't try and push for somebody who's a friend. Don't ask for Super Bowl tickets from a vendor. No local government officer or employee shall act in his official capacity in any matter where he, a member of his immediate family, or a business organization which he has an interest, has a direct or financial or personal involvement that might reasonably be expected to impair his objectivity or independence of judgment. So that goes back to the common law interest that we talked about in the beginning, but this is on top of page 5D. What's interesting about this particular paragraph, and it's probably the one that is invoked the most often, right? When we talked about an interest, the statute defines it, as I said earlier, ownership or control of more than 10%, yada, 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 right? And we talked about interest in the common law. Personal involvement, I think, broadens the area of potential conflicts. Personal involvement can mean a lot of things, right? And I think that's where most of the landmines lie, right? Because you don't even think about it sometimes, just natural. Bruce?
John, we've had a number of planning board issues come up. It's a small town. I'm not going to say everybody knows everybody, but just about. And these applicants come up for a project, and we know them. I think the warehouse on the corner switched hands 10 times. I mean, I personally knew Bob Shin had owned that property. He's a former mayor here. Everybody knew Bob. And of course, it changed hands to a former committeeman. Unbeknownst to me, there was some corporations about how should we behave on the planning board with instances like that we, we may supposed to know who it is, but sometimes we don't, and then sometimes we know, like the Revicchio piece, where a lot of us know Eric Revicchio as a longtime resident.
Yeah. So, and particularly in a small town, but even in a larger town, people are appointed to boards, people are elected. Let's go with electeds first, and we'll come back to appointments. People are elected because they know people, right? I mean, you're going to know people who come before you, right? I can't tell you, in 40 years, doing 6, 7 different towns, how many times someone has come to the microphone and 3 or 4 of the members of the governing body know that person. Doesn't mean they have a personal interest or conflicting interest. Doesn't mean they're doing business with that person. If they're doing business with that person, that's pretty clear red flag right there, right?
John, can I, when you say do business, like we use vendors in the town, that's not considered doing business. Like if I.
No, you're doing that as your, in
Exactly.
personal business.
When you say business, it doesn't.
Yeah.
Like if I'm doing a job for one of the vendors, that's a different story. But if I'm taking my car to get service at the vendor, I'm just getting a service. I'm not a customer, that's all.
Well, I don't know that we do a whole lot of that. I mean, if you're going to get your car serviced, I don't know that we're doing a whole lot of that, right? I mean,
Well, I get my car serviced one place, but every once in a while, they'll have something they'll ask me to do. Now, when that occurs, it's off limits. Yeah,
are they getting contracts from the township?
no.
Well, it doesn't matter. What you do personally, what you do in your private life is up to you. These conflicts are where your public responsibility meets a private interest, right? So if your best friend, if our vehicles are being serviced at Joe's service center, and Joe is your best friend, you shouldn't be voting on that. That's personal involvement, right? That's a personal interest, not a financial interest. You don't have a piece of Joe's business, but Joe's your buddy. You go down to Dunleavy's with Joe every other week. I don't know, whatever it is. But I mean, that's, and that goes again to the extent, right? How deep is the relationship? Well, how leadership, where it's not disclosed, nobody sits up there, whether it's the governing body or whether it's you as planning board members during a hearing, with a crystal ball in front of you that tells you, be careful, there is another person in the background that you don't know about because it wasn't on the corporate disclosure list that came in as part of the application, which is why those applications all have owner disclosure lists, applicant disclosure lists, right? You have to list any entity that has 10% or more interest in that application, whether it's the ownership interest, whether it's the applicant, because remember, the applicant's not always the owner, right? It's a contract purchaser or something like that. So if it's not disclosed, neither the board nor the committee can know that, right?
Yeah, I don't personally remember if it was disclosed or not. But I certainly, as a matter of due process, did not really concern myself with who the owners were, maybe as much as I should have, but, you know, I don't know if it necessarily.
Well, it might have mattered.
Conflict that should have been pointed out.
It might have mattered. Again, it goes to the extent, you know, on that hypothetical, I can't tell you yes or no, right?
I'd have
Not
to
enough
go back,
facts.
but, you know, like you said, funny season comes and you get all kinds of stuff going on.
John, recently we had a joint land use board client who is the lead salesperson for a landscaping company. He does a whole lot of business in Hayesport, taking care of individual properties. I was on the board hearing his case, it had nothing to do with this business, it was something to do with his home. Would that have been a conflict of interest?
Are you as customer?
This is all being recorded, this is all live, right?
It is, but
Yeah.
people are not hearing the questions from the audience.
Well, since it's already occurred, I'm not going to answer whether it was or wasn't.
Good move.
But I think that is a conversation that you would have to have with Bob before the meeting, you know, and look, a phone call well in advance of the meeting could save everybody a lot of time. It might save you a trip and get to stay home and watch Monday Night Football, or whatever it is, you know?
So maybe we should talk about a case when it comes to the planning board, somebody, and I don't know if it's necessarily available to us. I think I've seen names of it in the past, I don't know exactly what format. But maybe we should make a point to have the solicitor give us a list of principles to sort of see if there's a potential, you know, conflict of an interest in some sort of an open,
I don't know about,
area.
I don't know about that. I really think that invites more mischief than not. I can tell you that in one town I represented for a long, long time, and and it hadn't happened here, but it was because someone did have a conflict of interest, didn't realize it, right? And then all hell broke loose. So at the beginning of the agenda, after roll call and before minutes, there is matters requiring recusal of the members of the governing body. So it really invites everyone's attention to everything on the agenda. You're now looking at it more closely to see, do I have a conflict on anything on this agenda? You know, there's a member of the governing body in one town that has a construction business. And he's always recused himself from anything having to do with other activities. But you don't always realize what the performance bond that you're releasing is, or whose it is, right? You're not paying close attention to that. And so he would repeatedly ask me, can I, it's a release of the performance bond, it's been recommended by the engineer, it's not a big deal. No, if you're doing business with that developer, you're clearing land, I don't care if it's in North Jersey, right? You have that relationship with that developer, and even though it's a pro forma action to release the performance bond and accept the maintenance bond, it's been recommended by the engineer, no, you can't vote, right? So,
you know, I mean,
so on,
to me, it's disguised sometimes who these people are, who these actual.
well,
I'm not-
but that's why you're supposed to read the application. The application has the 10% disclosure.
Yeah,
I mean, if you're going to turn your planning board meeting into either the land use administrator or the solicitor reading to the board all 15 pages of the application before the application gets started, you know, that application is not getting heard for another month.
you'd have to go back and look, like you said, Monday morning quarterback, some of the cases.
John, I just want to make one point, whether, I once heard a planning board member said ShopRite was on he says, I can't vote on this because I shop at ShopRite.
Not
Now,
a
that's not the
conflict.
case, right?
Not a conflict.
Okay, thank you.
Not a
So it
conflict.
all depends on what level of customer you are, right? If you think it's enough, ask.
If you were going to have a holiday party and you were going to decide what's on the alcohol list, and I was sitting up there, I would not be disqualified from voting to add Red Breast 12-year-old to that list, okay?
Thank you.
Going back to D, which I said is one of the more common ones, right? that last clause has a direct or indirect financial or personal involvement, as just said, I think that's broader, that might reasonably be expected to impair his objectivity or independence of judgment. Reasonably expected. You know, it's not defined, but again, I think what it means is by people who are informed of all the facts and circumstances, right? Again, to avoid the knee-jerk, oh, that's a conflict of interest. I probably get that more times than legitimate conflict of interest questions. People just trying to stir the pot. You know, and not to go on another different soapbox, but, you know, this day of social media where people just blast nonsense out there about people, whether it's in October before the first Tuesday in November, or whether it's any other time of the year, right? There's little accountability for them, but there's a lot of accountability for you, right? And you find yourself having to defend yourself against nonsense, right? But that language is important, might be reasonably expected to impair by reasonable people fully informed of the facts, right? And then we'll skip to F, no local government officer or employee, member of his immediate family or business organization in which he has an interest, shall solicit or accept any gift, favor, loan, political contribution, service, promise of future employment, or other thing of value based upon an understanding that the gift, favor, loan, contribution, service, promise, or other thing of value was given or offered for the purpose of influencing him directly or indirectly in the discharge of his official duties, right? You just can't have your hand out. And again, I say this having represented hundreds of elected officials in 40 years. I can count on probably one hand, maybe two, where I thought there might be a chance that somebody was, you know, doing this, putting their hand behind their back looking for something. I mean, it just doesn't happen. It really, that's why I love doing municipal law. I mean, the people who are sitting up there, sitting there when you're sitting up there, generally don't do that stuff. But there are bad apples, you know, it's like everything else. These things are written for the bad apples, not written for the good apples, right?
It's still the same, John, if you're going over and asking someone who does work for the township for something, or they come up to you and give you something, it doesn't matter whether you're asking or they're giving it to you, you know, it's the same, correct?
Well, again, so this language is important, right? Because that line, based upon an understanding that the gift, favor, loan, contribution was given or offered for the purpose of influencing you.
Right.
Right?
Right.
That's a difference, you know.
Right.
And there is another section of the law that talks about calling, that you have to disclose gifts or contributions over $200, I think it is, or $400. To me, that's the threshold, right? That's where you have to disclose things. If you're out, if you're out and you're having drinks with somebody, and they pick up the first round or the second round, if that influences your decision, God help you.
Yeah, right, yeah.
And so the law assumes that there is some reasonable limit here, some level at which it now becomes a question. And that's purely gratuitous. But if you are that saleable and buying a dinner gets you a vote, then it's understood, I'm taking you to dinner so I can get your vote?
Right.
No.
Yeah.
No good. No good.
Can you come to the mic, because there are people online, or if you can come a little closer to this, or if you can hand her that microphone, that would be great. That's all.
A few years ago, when I was newer to the board, so this is probably, I don't know, several years ago, there was another contractor, I guess, somebody like, such as yourself, or, you know, one of the attorneys that works with the land use board, but they went through and they had offered tickets to, say, like the Eagles game, they had like box seats or whatever, or they had box, and so they offered that, or they had tickets to the Flyers, and they, you know, they were inviting us to come to that. So is that something that is off limits, or is that something that, like, hey, we're just being nice, and, you know what I mean?
Yeah, I do. It goes back to that clause that sets a dollar figure, right? I mean, if you're being invited to the Super Bowl, we all know what those tickets are worth. Forget
Thousands,
about it,
yeah.
right?
Yeah.
But a regular game is $100, $150, right? 200,
A
depends on
regular
the seat.
Eagles game?
Could be 300.
I haven't been to
Could be 400, yeah.
I prefer my sofa. I think it becomes an issue. You know, if you're going to, my recollection is Phillies games were what, $50, $45 for good seats? That's not going to sway anybody's vote, right? But if you're going to 10 or 12 of them, and they're box seats, and you know the value of each one each time is $150, and now you've gone to 10 of them, that's $1,500. I mean, that's a problem, right? So, I think it's, in those situations, the better course of action is always to say no thanks.
Yeah.
Right?
So one game is one thing, a Super Bowl or a championship game or
Yeah.
several games is it's something different.
Going to a Phillies game, going to a Sixers game, nobody's going to break a sweat over that, right? You're not, but start adding them up, and yeah, you got issues.
Right.
You got issues.
Yeah, well, it certainly doesn't look good either, even if it, yeah.
There's also provisions in the land use law, because I want to wrap this up, because we're way beyond what I thought would be. On page 6, there's one specifically for the planning board, right? And the municipal land use law specifically says, no member of the planning board shall be permitted to act on any matter in which he has, either directly or indirectly, any personal or financial interests. So that kind of combines both the local government ethics law and the common law, right, with those direct or direct or indirect personal or pecuniary interests. And so courts have established that language to mean this, and I'm going to read you. Quote, "The statutory disqualification is markedly broadly couched, extending to personal as well as financial interests directly or indirectly. And so the statutory bar is not confined to instances of possible material gain, but it extends to any situation in which the personal interests of a board member in the matter before it, direct or indirect, may have the capacity to exert an influence on his action in the matter." I think that's probably an indication of what the legislature meant by personal involvement when they adopted the local government ethics law and added that language to 22.5D, which was not part of the common law. But I think they meant that to be broader than just their statutory definition of what an interest is. And sometimes, because of the difference in the responsibilities and the roles of planning boards and governing bodies, planning boards and zoning boards are looked at maybe a little more strictly because you're weighing evidence, you're acting as judges, it's a quasi-judicial proceeding, right? This is legislative. So I'll give you one example of that, and then we'll kind of bring this to a close, because this is happening more and more. I don't know that it's a function of social media, but people shoot their mouths off more today than they ever did, right? So take an example where somebody runs for governing body, whether it's mayor, council, committee, whatever. And the town has adopted a cannabis ordinance, and they are just anti-marijuana, right? And they run on a platform of stopping, ending all this cannabis nonsense. I'm against it, we shouldn't have it, it's bad for, whatever their campaign literature says, right? And they get elected, right? And they go up to the dais now as an elected official, and they want to introduce an ordinance to repeal the cannabis ordinances that were adopted, right? Somebody might say, well, you can't do that. You have a conflict of interest. You're clearly against it. You're biased. You know, the answer is, so what? That's a public position on a public issue. They ran on that. There's no conflict. They said, if I get elected, I'm going to fight to repeal this. There's no conflict of interest there, because that's their public position on an issue. Now, take that same person who is appointed Class 3 member of the planning board, and an application comes before the planning board for a cannabis operation, whether it's retail, whatever it is, and it comes in for site plan and needs some variances. The same person who was eligible, in my view, to vote on an ordinance to get rid of something that they campaigned on, cannot now vote at the planning board level, because that bias now matters in their quasi-judicial evaluation of the evidence, right? The testimony that comes in, it is too clear that they may not be able to, from a public point of view, from reasonably informed people, they may not be able to view this application fairly and impartially because they set their campaign on anything anti-cannabis. So while I would rule that they're eligible to vote on an ordinance to repeal what they said they wanted to do legislatively, because that's a public position on a public issue, a legislative issue, that same answer does not apply if they're now a Class 3 or a Class 1, if they were running for mayor in a mayor-council form of government. I would say they cannot participate. They should actually step off the dais. They should just be gone, because in a couple of cases that came out in the last few years, the court made distinctions, where in one case, a mayor who was elected as the mayor in that form of government made just horrible comments about this golf course up in North Jersey. And it's a really good golf course. If it was a piece of crap golf course, I would excuse them from making bad comments about it, right? But this is a really good golf course up there, right? And he didn't think they were generous enough to the community. I mean, a lot of personal stuff in there, a lot of, you wonder what he was trying to get out of it, right? And he didn't vote as a planning board member. We went to the planning board keep in mind, the planning board is appointed mostly by the mayor, right? So the court said, you know what, you've tainted the whole proceeding, right? You just can't do that. And then there was another situation where the mayor took public positions against something, but stayed out of the planning board issue, didn't get involved in it, right? And had his designee sit there, and I think the court said, but that's okay, because he didn't gin it up, right? He didn't stand in front of the board that he effectively appointed, and/or one of his colleagues is on the Class 3 member, right? And an employee, the Class 2 member, right? So again, it goes back to the degree, the extent to which the alleged conflict, the alleged failure of impartiality goes, and that's why I say these are nuanced considerations. They're all fact sensitive. But that's a really good example of where it's different in terms of what would happen here as opposed to what would happen here. So I think it's probably a good idea to end it with that.
Yeah, okay, can we take a 5-minute recess?
Yeah.
All right,
It sounds great.
we'll do that, we'll do.
Thanks, John.
All right.
Appreciate it very much.
Thank you, John. And adopt and redevelopment plan for a certain property known as Block 72.01, Lot 1, and a portion of Greenwood Avenue, approximate to Block 72.1, Lot 1, Haynes Mobile Home Park. This is a first reading and introduction.
On introduction, if I could, just, there will still be a blank, but in your first paragraph, at the end, dated November blank, is now dated November 30th, so if you would insert 30. In the third paragraph, when does the planning board meet next?
December 6th.
6th?
Or,
12th?
yeah, 6th.
I thought it was the
We meet
6th.
the 12th.
Okay, yes, they said
6th.
here.
It says
6th? Oh, mine's blank.
Do you guys know?
Are you for
it's in your
6th?
binder?
Oh,
Yeah, I think it's
Planning board?
6th.
I thought it was the 6th. That's what, didn't we discuss?
is that already filled in?
Yes.
Okay.
But you're right on the redevelopment plan itself, that the 21 that's on your ordinance, it should read the 30th.
Okay.
That's the one I sent to you today, electronically.
Yeah, so.
Oh, okay.
Dated to November 30.
And then the third whereas is December.
So on the front cover, it should.
Yep.
it should
All right, good.
say the third, okay.
Okay.
Any discussion?
I have a discussion. Just that, and I just want to, I think this is really nice that we're doing this. I think it's good that we're doing this. I think it's a win-win-win-win for a number of different reasons. I like the plan. And I also just want to make sure that on one of the pages there, and I spoke already about this, just about there aren't going to be people relocated temporarily or permanently from this. This is all going to be worked around, and that's in the plan right now.
Yeah, there is no relocation of
Right.
anyone.
So I just wanted to confirm that, because obviously we have to say that if for some reason something happens, that needs to be, it's statutory, I assume.
Or we would have to provide.
We have to provide it if that's the case, so that's why it has to be written here. But I wanted to make sure that at this point, there is none of that right now.
Where is that at? What page number are you?
Should be in the back. It's on page 20, top.
There it is, whole section on it. Okay.
Mhm.
Okay, John, on this, is this just an introduction, no vote?
Well, you have to vote to
Okay.
introduce, so a motion to introduce on first reading would be
Okay,
in order.
motion to introduce on first reading.
I will make a motion to introduce the first reading.
Second.
Roll call.
Mr. Montgomery?
Yes.
Mrs. Gilmore?
Yes.
Mr. Levinson?
Yes.
Mrs. Evans?
Yes, if that's me.
Hey, there she is.
Hi. Yeah, I've been here all along. Sorry.
And Mayor Cox?
Yes. Okay, we're going to go down to resolutions. Can I do all three of these together?
You can do the first two.
Okay. Resolution 2023-137-11, affirming the Township of Hainesport Civil Rights Policy, and 2023-138-11, adopting the Personnel Policies and Procedures Manual Employee Handbook. Can I get a motion?
So moved.
Could I get an answer to my question, Paula, that I sent you by email?
With regards to the training on the,
Wait a minute, time out. No, you need a motion and a
Okay.
second, then you can ask the question.
I need a second.
Second.
Okay, now you can ask.
okay. Was that on the training, the protection and safe treatment of minors?
That's the one, yeah.
Okay, so there is a link, and I believe you should have a username and password already set up with the GIF remote training modules. That is a remote learning experience that you can go on and take at any time.
Okay.
I believe Committeewoman Gilmore did it that way, and that's fluid, available 365 days a year, and you can do that if you want when we get off the phone, when we get out of our meeting. So it's on the Borough Code GIF website.
That link out again?
It's the Borough Code GIF, Burlington County Joint Insurance Fund. The link is available on their website. If you go on the training,
Okay, then.
yeah, I'll send you, I'll try to find the direct link to that. And-
I'd appreciate that, thank you.
Sure.
Okay, any more discussion? With that, can we get a roll call?
Mrs. Gilmore?
Yes.
Mr. Levinson?
Yes.
Mr. Montgomery?
Yes.
Mrs. Evans?
Yes,
Mayor Cox?
Yes. Resolution 2023-139-11, approve a firefighter into New Jersey State's Firemen's Association.
So
Thank-
moved.
Second.
Mr. Levinson?
Yes.
Mrs. Gilmore?
Yes.
Mr. Montgomery?
Yes.
Mrs. Evans?
yes.
Mayor Cox?
Yes. All right, we're at that time when we get comments from the public. Your comments will be limited to 5 minutes each. And do we have any takers?
You get 15 tonight, because you don't...
I'll give him 30.
Okay, with that, none. Do we have anybody online? Okay, looks like we're going to close public comment. All right, let's get some comments from the administrator.
I do not have any tonight.
Spectacular. Okay, how about comments from our solicitor?
Ditto.
Nice. How about from our committee? I'm going to go with Anna.
I'll keep this brief as I am at the airport, but thank you, John, for a very interesting training session, and I'll see you all very soon. Bye.
Safe trip.
Okay, with that, we'll go with Bruce.
Again, I also want to thank you, John, and I hope everybody had a great Thanksgiving, and with all that, I'm finished for this evening.
Leela?
I just want to thank John for taking the time out to give us this important information, and wish everybody a safe trip to Anna, and everybody hopefully has a good holiday season.
Okay, Deputy Mayor.
So, thank you, John. I appreciate your taking me up on this when I asked you to do this refresher on ethics. I think it's good, always good to be refreshed, so thank you. And also attended the New Jersey League of Municipalities, along with my colleagues here. Attended a number of different courses on a number of different topics to make, I feel, me more efficient in what I'm doing here. I'm sure everyone else feels the same. So as always, it was good use of time. And with that, Merry Christmas, Happy Hanukkah, and appreciate it.
Thank you. All right, I want to say that the toy drive at, I forgot his name.
Ron Capsetta.
Capseta's was excellent. We really did raise a lot. I believe that they're also collecting when we do our tree lighting, which has been postponed a week due to inclement weather. So
Wait, the tree lighting is not tomorrow?
That's not tomorrow night, it's next week.
Ah.
We have inclement weather scheduled for,
Ooh, okay.
Friday the 8th.
yeah, so that's not going to happen. And other than
I
that,
thought it was supposed to be moved to Sunday.
Sunday's inclement weather too.
It's the whole thing.
Apparently, everybody's canceling their tree lighting.
Okay.
So you have the menorah lighting penciled in on the 7th,
Right, I have that,
and
yeah.
you have the tree lighting on the 8th.
Okay.
And bring toys. I do believe that the fire department's collecting for Toys or Tots.
Yes.
So we'll make sure we try to keep that going. This town is very generous to the children of our town. And it's excellent. With that, I'm going to say, everybody have a great, we're going to be back before Christmas. Oh, yeah, I did cook barbecue for the, I was in my,
Element.
coveralls and, overalls and cooking barbecue, so.
We're back on the 12th, right?
Yes, we're back on the 12th, and, I did want to mention, on the 12th, we will have a guest mayor, and you're going to have to see who it is when he's here. He's a 7th grader from the school, and he won mayor for the day. So his day will begin with his mother dropping him off here at noon with permission to leave the school. He'll be able to inspect some equipment, see how things work in our town, and he will help run the meeting that night on the 12th. So I'm very happy that we can do this for this young man.
It's nice to be able to do it again.
Yes. So with that, I'm going to...
In Hainesport, that's considered, you won the contest. In some towns, that would be worse than detention.
Good point, John. Very good. And with that, we have to pay some bills. So do we have a motion to pay the bills?
So moved.
Second?
All right.
Yes.
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 Yes. Do we have no executive session tonight? That's great. So can I get a motion?
Oh, there is no executive?
No, I
So-
don't have anything to report.
Okay.
So can I get a motion to adjourn?
So moved.
Second.
All in favor?
Aye.
We're adjourned.
Nice.